Can California officers use a mobile fingerprint scanner? Hey guys, my name is Anthony Bandiero, attorney and senior legal instructor for Political Law Enforcement Training, bringing you to Roadside Chat. This question comes from an officer in California, of course, right? You guessed that. So the officer says, look, in California, a person is not required to identify themselves during an investigative detention. Let's stop right there. That is true. Under Penal Code 148, a person cannot obstruct the lawful duties of a police officer. A person cannot give a false name during an investigative detention. However, California law does not require that a person actually identify themselves during an investigative detention. And you might be thinking, but Anthony, in my state, we require it. That's because you have the law that allows it. The U.S. Supreme Court, in a case called Heibel, allowed cops to enforce stop and identify statutes if you have those on the books. But some states, like California, doesn't have a law to basically require people to identify themselves. Therefore, there's no legal requirement that a person identify themselves during a detention. All right, let's continue. I understand that police can use a reasonable means in order to identify the subject, right? Compelling them to identify themselves is one thing, but how about Facebook, talking to a friend, hey, who's this guy? Would that include using a mobile fingerprint reader that is readily available in order to learn the identity of the subject? My understanding is that these readers do not store the biometric data, and I believe that it would be viewed as reasonable means in order to identify and would not violate the Fourth Amendment. Now, Penal Code 832.19 has a section in which it specifically talks about the use of fingerprint scanners. So this Penal Code 832.19 is about storing biometric data. It's about facial recognition. A lot of states are trying to deal with this. They're concerned about police departments using facial recognition to eliminate or eviscerate privacy interests. And it talks about you can't store this, you can't do this, you can't, blah, 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 right? But then it says in here, this section, right, the whole biometric data restrictions, this section does not preclude a law enforcement agency or law enforcement officer from using a mobile fingerprint scanning device during a lawful detention to identify a person who does not have proof of identification, if this use is lawful and does not generate a result or result in the retention of any biometric data or surveillance information. Okay, so two things that I want to answer. Number one is, in general, for my friends who are cops in places that are not in California, are you allowed to use a fingerprint scanner under the Fourth Amendment? The answer is yes. Yes, if that fingerprint scanning will help to confirm or dispel your suspicions, right? So, you go up to a person and you thought that they purchased narcotics, right? But instantly you realize that from a homeless person, but instantly, the guy, you didn't see him, it was at night, and you go up to the person and you start talking to him, and you instantly realize that this person is a pastor for a local church who engages homeless people to try to get them off the street. And you know this person for a long, long time. And what you saw was, you weren't sure anyway. And you talked to him, was like, no, just handing him some coupons, whatever, for a meal, right? And you feel like your suspicion has been dispelled. Could you still fingerprint that guy? Right? If you have a statute that says, you can fingerprint this person, right? Or identify this person, the answer is no, right? At this point in time, the identification is not going to help you confirm or dispel your suspicions. They've already been dispelled. So let's have a reason for doing it. The second thing is that we know is that if you have a reason for doing it, the taking of the fingerprint does not violate a person's reasonable expectation of privacy, right? Because fingerprints, you leave them all over the place, right? It's like your face, right? Or the sound of your voice, or your handwriting. Generally speaking, people do not have a reasonable expectation of privacy in those physical characteristics. Going back to my friend in California, if you had a reason to take it, if the identity was important, if running this person's criminal history was important to help you confirm or dispel your suspicions, then it's not going to violate the Fourth Amendment, okay? And it's clearly not going to violate the Penal Code 832.19. So can the cops take it? Yes, if they have a reason. All right? Keep the questions coming. I hope this video has helped you get it right every single time.